Good afternoon, and thank you for coming to the analysis of mandatory hookup law and steps to fight it, put on by Water Systems Council. We're glad that you could come today, and we're going to talk about a very important issue across the United States. We get a lot of inquiries about mandatory hookup. And so I'm going to give you a brief overview. In 2018, I completed an update of our 50-state overview of mandatory connection. So I'm going to talk about what we found on that. That edition included an extra special bonus for everybody. I talked about building codes, and I kept hearing that across the country, people say that mandatory hookup was in the building code, and that sounded odd to me. So I said, I'm going to look at every building code in the United States and see what's going on here. I'm going to focus on a few states that have done some really notable things, either in fighting mandatory hookup or being able to pass legislation or fighting it in court. And then I'm going to go over, we have done a recent publication on how you fight mandatory hookup, and then we will go over some conclusions. Be happy if anybody has any questions to try to answer any questions today. So let me give you a broad overview of states and local government and how that works. States have, well, let me go back even further to the Constitution. And the Constitution limits the authority of the federal government. The federal government only has that power that is specifically set out to the federal government in the Constitution. Everything else goes to the states. So the states have a lot of authority, a lot of power in our system of governance. And that includes the police power. The police power is the power to protect the health, safety, welfare, and morals of the citizens. And the state holds that, and that can include mandating connection to water and sewer. So if the mandatory connection provision comes from the state level, you're going to have a very, very difficult time fighting that because the state has a lot of authority. So a lot of times we'll take a legislative approach to that and try to get something changed at the legislative level. But you can have some court fights. They're going to be difficult. Local governments don't have any authority unless the state gives them authority. And so that's where we can often be successful in these fights, is where the local government, without authority from the state, says that you can't use your water well, or you have to hook up to the local government or local authority water. In a lot of cases, I would say in at least 75% of the cases that I've handled, when we ask that first question of them, and the first question is, where do you have the authority to do this? They often don't have authority to do it. And so that's a great first step. You have to do that first step. And I should mention water authorities. Water authorities are even at a lower level than local government, and they definitely only have the authority that the state has given them. So it's important to hold them to their authority. And again, the first question that you should ask those water authorities, again, is where do you get the authority, the power to do what you claim you can do. So there's a few different varieties of mandatory connection. Sometimes they say you must connect to public water and plug any water wells that you have already. Sometimes they'll tell you that you can keep your water well until it fails, and then you must switch over to public water. And in the meantime, they'll often force you to pay some type of minimum monthly fee, and often a hookup fee if you want to do that. And then finally, in some states, they will force you to connect to public water to use for indoor uses. But if you would like to have a private well for outdoor uses, they will allow you to do that. And North Carolina passed a statute in 2016 that I'll talk about here in a few minutes that includes that option. So you have to look at your state laws carefully to see exactly what is allowed and what is not allowed. So I looked at all 50 states and checked the cases, the state statutes, the laws that the legislature passed, and I came up with 24 states that have state laws or state statutes that mandate water connection, at least in certain circumstances. And I have kind of an asterisk beside Vermont, because in Vermont, the mandatory hookup appears to only apply in Burlington. So you look through the states there: Virginia, Alabama, Arizona, Kentucky, Florida, North Carolina, which is another big state for water wells. They all have state statutes that require a hookup to public water. And those state statutes are difficult to overcome. Now, 7 other states don't have anything passed by the legislature, but they have court decisions that allow mandatory hookup. And that's Illinois, Indiana, Michigan, Minnesota, New Jersey, New Mexico, and Rhode Island. And those other states in my case law list of mandatory hookup that are not in bold, those states have both cases and state statutes that allow mandatory hookup. Now, if the state only has a case that mandates hookup, you still have the option of going to the state legislature and seeing if you can get a more favorable rule. But for the states that have state statutes that mandate hookup, it's really difficult. You would have to get the state legislature to change that law. And it's very difficult to attack these state statutes successfully. I found 16 states that I could not find any authority either way, including California, which I think has had some mandatory hookup questions here recently, Connecticut, Utah, West Virginia, my home state of West Virginia. The case law doesn't really tell us anything either way. And Kansas has an attorney general's opinion that is favorable for mandatory hookup. Attorney general's opinions are not binding, they're not mandatory, but they are persuasive. So in Kansas, there's a good chance that local governments can require that you hook up to water, but also that's just an attorney general's opinion, so you might have some room to fight that and to argue about that. Only 3 states that I could find, Georgia, Missouri, and New Hampshire, have state statutes that explicitly say in the statute that property owners have the right to have their own private water well. Now, Some of those are limited in certain ways, where it's only in municipalities. In Georgia, they recently got that passed, and it was some horse trading going on, and I'll talk about that in a minute, where they basically said we're going to allow Atlanta and Savannah to mandate connection to public water. And I think the rationale was people in Savannah and Atlanta aren't going to have water wells likely. So that was one of the trade-offs. And only one state, Georgia, has judicial authority that clearly comes down disapproving mandatory connection. And I'm going to talk about that in just a minute also. So overall, there are a lot of states that allow mandatory hookup. That can be through state statute or through court opinion. And there's relatively few states that explicitly say no mandatory hookup. And so hopefully we can start working on that and change that a little bit in the future. First, and I've got these in reverse chronological order, I'm going to start with the statute that Georgia had passed in 2007. In 2007, the Georgia Association, Bruce and Ashley Widener, and the officers there in Georgia, they made and this has been going on for a number of years. You don't get a bill passed the first year that you introduce it. When they were able to get a bill passed that protects the right of Georgians to have a water well in most situations. They did some horse trading, and you have to in many instances. We're probably not going to have a water well in downtown Atlanta anyway, or downtown Savannah. And so they gave that up. But in most parts of Georgia, and particularly in rural Georgia, you can have a water well, and they cannot require you to hook up to public water. And that's because of the great efforts of Bruce Widener, Ashley Widener, the officers and directors of the Georgia Association. They did a fabulous job of lobbying that and kept going back to the legislature over and over until they were finally able to get that passed. They worked with a lot of other organizations and groups. And so that's a model of how you get a statute like that passed. They were also able, and this involved the Georgia Association as well, they helped fund this and they were behind this a lot. Water Systems Council also got involved in the Ashley versus City of Sandersville case. I was able to help out the local council on there, and we got a very strong opinion from the court that the local ordinance that denied a permit for a residential water well where city water was available. So the ordinance said, if you can have city water, you must have city water. They were able to have the court say that's unconstitutional. So it's a very strong opinion. So Georgia now has the double protection of a court decision and a state statute. And again, a lot of the credit goes to the Georgia Association. And I'll talk about that more when I talk about how to fight mandatory hookup. Missouri is another state that has a state statute that explicitly protects the right to a water well, but it's a little more limited. It's more limited than Georgia, I would say, because it has some strong language there that landowners in Missouri retain the right to have, use, and own private water systems, including systems for potable water, anytime and anywhere. I like that language there. But it says including within city limits, but then it has the limiting factor unless prohibited by city ordinance. So cities in Missouri can mandate connection, but counties are not allowed to. So many rural areas are protected in Missouri. The next state that has a statute that protects the right to have your private water well is New Hampshire. And New Hampshire's language is very, very strong. No property owner shall be required to connect to a municipal corporation furnishing water, provided that the property owner can demonstrate the ability to comply with the state well requirements. So as long as you can put a water well in that complies with those state code requirements, you can have a private water well in New Hampshire. So very strong provision there. Nebraska has a case that I think probably gets it right. Even though I love Georgia's case because it's a very broad, protective order that says it's unconstitutional. But in a lot of states, let's face it, the municipality, the local government is putting in public water as a way to generate revenue. And they're mandating hookup as a way to generate revenue. And local ordinances should have a legitimate public purpose. And that, in this case, would be generally to promote the health, safety, welfare of the citizens. But making money or subsidizing the sewer service or making sure you have enough money for debt service, that's really not a legitimate public purpose. And the Nebraska Supreme Court recognized that. And they said, just because there's a potential that these private water wells could be contaminated, that's not enough. There has to be a real and substantial connection between the exercise of that police power and the health, safety, welfare of the citizens. And just saying that the water well might be contaminated is just not enough. And so the court in that case struck down that ordinance. But I want to say that Nebraska and Georgia are rare. They are the exceptions and not the rule. We have a lot of court cases that frown upon private water wells, to be honest with you. I think Mississippi is a good example where the court case in Mississippi talked about private water wells often being contaminated and not safe and not healthy. And that will get to something that I talked about later, that we have to educate not only the public, but judges and lawyers and others to make sure that they understand that well water is a safe, efficient, plentiful supply of water for many, many Americans. And this is also in contrast to the Kansas Attorney General opinion, who said you don't have to have anything specific. In Kansas, according to the Attorney General, as long as you can say that this is for the health, safety, welfare, you don't really have to back it up. That's enough. You can mandate water connection in Kansas. I want to talk about North Carolina as well. In 2016, North Carolina added some provisions to their state code on mandatory hookup. And prior to that time, North Carolina had not been very favorable to private water wells. And these amendments are not perfect, but they certainly are better than just a broad mandatory hookup requirement. So they basically create some exceptions. And the first exception is if you have undeveloped or unimproved property that's served by public water, but the public water is not directly available yet, you can get a permit for a private water well, and you can use that private water well. There are some exceptions. If your groundwater is contaminated, you can't get a permit. And if the public water supply is funded by certain sources, you cannot get a private well permit. But otherwise, that's a way that we have an exception to mandatory hookup in North Carolina. The other exception is something that I often hear about, and that is if you are hooked up to public water and you use public water for your domestic purposes inside of the house, in North Carolina, you can now get a permit to have an irrigation well. That irrigation well cannot be interconnected with the public water system, and it must only be used for irrigation purposes. But that exception provides at least some relief for homeowners in North Carolina. And I think it's just a really interesting compromise that they came to. And again, sometimes you can't win every point. So you have to see what's the best we can do, what compromise can we come to. And who knows, maybe after several years of trying this experiment, it could be expanded and allow exceptions in other cases. So very interesting in North Carolina. Next, I talked about earlier that I looked at all the building code for all 50 states. That was a fun weekend. The West Virginia football game was later that Saturday, so I spent most of the day reading building codes. And what I found out was pretty interesting, that basically there are two types of model building codes that are used in the United States. The first is the International Building Code, and it's a slight majority of states in the United States, and you can see those states listed there. The International Plumbing Code, and I'm sorry, I said building code. The plumbing code is part of the building code, but I was specifically looking at the International Plumbing Code. The International Plumbing Code requires that you hook up to public water if it's available. And a number of states have adopted that code. I think it's very strange to have in a plumbing code a mandatory hookup provision. And I'll note that Missouri, New Hampshire, and Georgia, the three states that protect the right to a private water well in their statutory provisions, all have the International Plumbing Code. So I wonder if those states even know that their plumbing code conflicts with their statutory provision. And I also wonder even how would you enforce mandatory connection through the plumbing code? So if we have people listening who have encountered mandatory hookup through the plumbing code and have seen it in operation in any way, I'd like to hear from you, because I know that it exists, and I've heard from contractors who have run into it, but I just think it's a really odd way to do mandatory connection. Now, the other building code, plumbing code, is the Uniform Plumbing Code. It does not require a mandatory hookup, and it's used in a significant plurality of states in the United States that you can see on the slide there. Hawaii, Arkansas, California. So significantly, California uses that code. There's also 2 states that use the National Standard Plumbing Code, Maryland and New Jersey. That also does not require mandatory hookup. And Wyoming, I could not figure out. Wyoming, I couldn't determine whether they had their own building code or if they adopted one of the uniform codes. So anybody from Wyoming who knows the answer to that, get in touch and let me know. Now, given that baseline, 4 states that adopted the International Plumbing Code removed that mandatory connection provision. So states can do that. For the most part, local governments cannot, but in some states, the state gives the local government some authority to change the provisions of the plumbing code. So Indiana, Michigan, North Carolina, and Ohio removed that mandatory connection provision. Well, on the flip side, Minnesota's plumbing code did not have mandatory hookup, and they decided to add it to their plumbing code. So when you tally everything up, 28 states have mandatory connection in their plumbing code. Water Systems Council has been involved in several uniform codes relating to water wells. And we are now looking at the possibility of seeing if we can have that mandatory hookup provision removed from the International Plumbing Code. Like I said, it doesn't make a lot of sense. I don't know how it would be enforced. It just seems like it's out of place in the plumbing code, at least to me. So we're going to check that out and see what we can do. So now we're going to move on to what I want to say is the more important part today. When you really can't fight mandatory hookup until you know all of the baseline that I just talked about. But once you find out what the baseline is in your state, what you have to deal with existing law, then you can turn to, well, what do we do when the local government, when the water authority, when someone says you must hook up to public water, you have to get rid of your existing well, you can't use that anymore. What do we do? Well, the first thing you always have to do is say, can they do that? Do they have authority? I always tell them, I'm from Missouri, show me. Show me the state law, show me the ordinance that gives you the authority to do this. And in many, many cases, they don't have the authority to do it. There is a principle of local government law, and I don't want to bore everybody, but it is something that I've done a lot of work on and I've looked at throughout the United States. It's called Dillon's Rule. And it's named after Judge Dillon, who was an Iowa Supreme Court justice in the mid-1800s. And Judge Dillon didn't think much of local governments, to be honest with you. And so Judge Dillon came up with a rule that courts use when they're trying to figure out whether a local government has a certain authority. And that rule says that the local government has no authority unless that authority is expressly granted to the local government or that authority is necessarily implied in those express grants, or the authority is absolutely necessary for the local government to operate, not merely convenient. So those are the three exceptions. And then Dillon's rule says, if there's any fair, reasonable doubt as to whether the authority exists, it doesn't exist. So it's kind of like if you have to ask, you can't afford it. If you have to ask, you don't have the authority in general. Now, 8 states don't use Dillon's rule, and I've listed them there: Arkansas, Iowa, Massachusetts, Montana, New Jersey, New Mexico, Ohio, Oregon, South Carolina, and Utah. However, so those states, you might have a more difficult time. However, just our system of governance in the United States says that local governments are inferior to state governments. So even in those 8 states, you still have to ask, do you have the authority? And where do you get it? So that is where we always, always, always start. Another really important thing is, don't wait until a municipality says you can't have your well. Don't wait until your customers start getting those letters in the mail. Start thinking about mandatory hookup today, if you haven't already. I always talk to water well contractors and others in the industry about the importance of being involved in state and local governments. Really, with water, especially groundwater and especially water wells, there is a lot that can be done at the federal level. And I don't want anybody to mistake me for saying there's not. But really, the bulk of what happens is at the state and local level. So be involved in your local government, be involved in your state government. When your local council, city council, county commission, when they think about groundwater, when they think about public water versus water wells, they should think about you. And they should think about the water well contractors in the area, because they are the experts in the area. I want to give a short story, true story about in Maryland. So I was working with a county in Maryland Maryland has some very unusual groundwater laws. And so I was working with them and talking about what they could do at the local level. And they decided to have an information forum for citizens to come. And it was on a Saturday morning, and I think it was in February. But what I do remember is getting up that morning, and it had snowed, and it had rained, freezing rain, and the roads were really icy. And I had like a 2-hour drive in that stuff. And I said, nobody's going to show up for this. But I went anyway. 120 people showed up. They packed the room, and they wanted to hear about water wells and groundwater issues. Included in the crowd were some officers and directors of the Maryland-Delaware Association. After the workshop was over, one of the local government officials came up to me, and the first thing he said was, "Did you see all the water well contractors here?" That made a real impression. And that's what you have to do. You have to show up for these things. And I know you're busy. You have work to do. You don't make money when you go to these local and state government um, uh, events or information sessions or meetings. But they have the power at the state and local government to prevent you from making any more money if they mandate hookup. So it's very important that you do that. Also, extremely important that you're involved in the state and national associations. We always say at Water Systems Council that it really centers on the state associations. The state associations, they are our eyes and ears. They are the link between the water well contractors on the ground and people like Water Systems Council and other national organizations that can help. And so your first phone call when something happens should be to your state association. One real issue that we have with water wells is that the public water suppliers, they have a list of customers that are required to be part of public water. And they can also just raise everybody's taxes and go to court and sue and force people to connect. Water well contractors, a lot of us don't have a list of our customers. We don't regularly communicate with our customers, so we don't know who they are. We don't have the ability to contact them immediately. I think you should try to keep a list of your customers, be able to contact them when something like this comes out, so you can have like a force of people, a group of people that can gather together to fight these kind of things. But again, it all goes back to the state association. They hopefully have a lobbyist that's keeping an eye on the state legislature. You probably have a legislative committee, I hope. And a lot of state associations go to the state capitol once a year to talk to their state legislators. Those are all very, very important things. And if you call the state association, they can get in touch with me, with the National Groundwater Association, with other groups to try to pull together. They can help fund these fights, and they're not cheap. They can help you have a critical mass. Again, I'm going to use Georgia as an example of this. When they were able to unify forces and fight that court battle, and they were able to go back to the legislature year after year after year to get legislation passed. And I'm going to talk about Washington State in a little bit as well, because they've done a great job with some challenges that they've had in Washington State. And I don't mean to slight all of the other state associations, because we've worked with New Mexico and Minnesota and Montana and Nevada. And I hope I haven't missed anybody that we've worked with. Actually, in one exempt well case, we worked with about 20 state associations. So there are a lot of you out there doing wonderful, wonderful work. And please contact your state association. That means you have to be a member of your state association, by the way. And I think you should, because that's a way that you can magnify your voice and make sure that your voice is heard. It's also important to assemble your professional team, and it's good to have these people, if not on retainer, at least have them in mind before you need them to go into battle. Your lobbyist, I've already mentioned, is very important. things are happening at the state legislature almost every day, and you need somebody to monitor those activities, and that's your lobbyist. And you need to know that there's a lawyer that you can get to fairly quickly to represent you. And we can help, groups can help, but you have to have a lawyer in your state that's going to prosecute the litigation for you. And it's good to have that lawyer in mind ahead of time at a minimum. And that's a difficult thing. One thing that I want to mention about why we lose a lot of these court cases is it's just human nature. On one side, you have lawyers that are funded by the taxpayers. They don't have an unlimited budget, but their budget is certainly usually bigger than the lawyer on the other side. The lawyer on the other side, if he's not being paid very well, if she's got competing cases, and in one case she's getting paid $20,000, and in the other case she's getting $5,000, it's just human nature which file is going to go to the top of the stack. The other thing is a lot of local lawyers don't have specific knowledge and experience on water wells, and that's understandable. Most attorneys in most areas, they can't focus on water wells and groundwater because there's not enough cases for them to make a living. And so they're going to do divorce and criminal work, and they're going to do a variety of things. But there are a lot of great lawyers out there, great litigators. They know the local courts, and they're good at it. And so if you combine a good local lawyer with some knowledge from national and state organizations, we can help. We can be their backup, help them with information. Then you've got a chance. And also the scientists, the hydrogeologists, they're extremely important as well. Sometimes I say they're more important than the lawyer. You've got to know what's happening in reality in the ground with the water so that you can fight this properly. I mentioned this earlier, it is so important. Educate, educate, educate. And the number one thing that we keep coming back to when we look at these things is that we've got to educate the general public. We have to educate lawyers, judges, state legislators, local legislators on what this means if you mandate connection. We can do webinars like we're doing today, workshops, seminars, conferences. And Water Systems Council has done these types of conferences in Montana, North Carolina, and Florida. And Florida in particular was a local government that wanted to mandate connection. There were a lot of citrus growers in the county. And they said, if you make me use public water to water my citrus groves, not only is that really expensive, but it kills my trees because of the chemicals in the water. So we had a conference, and the conference was very neutral. We stuck to the facts, but it got the facts across. And when I say numbers versus the right people, we might not have 150 people at all of these conferences, but we have the right people. We get state and local legislators, get your state representatives, get your local council people or commission people, get them to come hear what you have to say. In Florida, we had local officials come and thank us and say, thank you for doing that. We did not realize that if we would have mandated hookup, that it would have had all of that adverse effect. And my last bullet is a bunch of dollar signs. What we as an industry need to do a lot of times is explain to the people who make the rules how much dollars and cents impact the water well industry has. And Washington State is a great example of that. In Washington State, they had a huge problem that basically shut down water wells in rural Washington State for over a year. You cannot build a house. The state association did a lot of work on this, and they got an assist from the home builders who did a study, and it showed the billions and billions of dollars that not being able to build homes had cost Washington State. I don't think it was a coincidence that the state legislature finally came to their senses after seeing what these numbers said. And the other thing, Water Systems Council can provide you with some case studies that show the cost difference between putting in public water and putting in private water wells. And it's huge. The cost differential is just huge. And a lot of times when state and local and federal officials see that we're not asking them for money, we're showing them how they can save money, it makes a huge difference. We can't afford to run public water pipes all over the United States. We need to have private well systems. Let's show everybody and educate everybody how that can happen and what benefit that has for us. You need to have a group of people, I think, to help finance things. It is going to be costly. The state association can help, but you're going to need people to help finance this. And sometimes our customers can be our strongest allies. Now, I say have a management committee because I've done a lot of these lawsuits representing groups of people. And the problem occurs when I have 25 clients or 30 clients, and I have to talk to all of them about everything. Not only is that really cumbersome, but what I've usually found is that there's always at least one in the group that's either a mole or they can't keep things secret. So I will tell confidential information to my clients, and sometimes it gets out. So for managing the case, I think you need to pick one or two people, or three at the most, that are going to manage this, and they're going to be the conduit to the lawyer. Keep things confidential, keep things moving. And last, a lot of people are excited about suing the city or suing the county until they found out how much it's going to cost. Or a lot of times what I get is people that say, I support this, but I don't want my name in the paper. You have to, at the outset, say, we are going to be willing to do this, and we're committed, and we're not just going to send a nasty letter, and if they ignore our nasty letter, we're going to go away. You have to be ready to take it to the mat if you start. So think of that at the outset. It's all political. All politics are local, and politics are involved in this. So keep that in mind. You might win the lawsuit, and the state legislature might change the rule. You might get the law changed, and then a court rules against you. It ain't over till it's over. So you have to keep moving forward, keep alert on everything that's happening. Like I said before, be ready to spring into action. Don't wait until something happens. Not only do you have to have your experts ready, but your lobbyist has probably already talked to, communicated with home builders, farm bureaus, real estate agents, other groups that might be on our side. Now, they're not always on our side. Well, when you're working through legislation, keep those friends in mind. And sometimes they might be not your friend on one situation and they're your friend on another. So get those groups together. And again, that's where Washington State did a wonderful job of building those alliances. The Washington State Association is very small as far as state association goes. But when they were able to align themselves with the home builders, the Farm Bureau, and others, they all of a sudden became very big and more powerful. They've done some amazing things there with not a lot of resources. But Glenn Smith and the officers and directors there in Washington State have done tremendous things there. So I close with 10 questions that you should be asking the water authority or the local government if they mandate connection, if they threaten to mandate connection. First, of course, is where's your authority? Tell me where you have the authority to require that I hook up or to put restrictions on my water well. The second question to ask them is, have you gotten a legal opinion on whether you're allowed to do this? And if they say yes, say, I would like to see that. You sometimes have the right to see those types of things. And it doesn't hurt to ask, of course. And maybe you want to get a legal opinion. I have done several legal opinions for state associations. Ask them what the purpose of the requirement is. Under the law, the purpose should be your water is contaminated or your water wells are not safe. But we all know that's rarely the case. So ask them, are you using mandatory connection to raise revenue? Are you using mandatory connection to subsidize the sewer? Public sewer is very expensive, and many local governments will use their public water to subsidize the sewer. Is that what they're doing? Do they have any evidence that the water wells in the area are contaminated, or they're not producing sufficient water, or for some other reason are not adequate and you have to bring in public water supply? And then get to the dollars and cents. And this can sometimes be really shocking. How much is this project going to cost? And how many households is it going to serve? And then do a little math and say, wow, that comes out to $40,000 per household, or whatever that might be. And then you can look at the possibility of using less costly options. We now have federal legislation that says that certain small communities have to look, they are required to look at the option of private water wells. We're not telling local governments they have to use private water wells, but they should at least look at that option. And now the EPA is in the process, along with Water Systems Council, of building that database to get information on these private well systems. And that's often much less expensive than public water and will save the local government money. So it's something they should look at. can you pay for this project without forcing people to connect to the system? A lot of times they will mandate connection because that's the only way that they can afford to do this. Ask about the environmental impact. Often the environmental impact of such a large system where you're running pipes for miles and miles and miles, the environmental impact can be very bad. And when you compare that to private water wells are also often preferable in that regard as well. So ask that question. And last and certainly not least, try to see what documents do you have, what communications do you have relating to this. See if they'll give you documents voluntarily. If you suspect they're not giving you everything or they won't give you anything, talk to an attorney about helping you to file a Freedom of Information Act request for copies. There are certain things they don't have to give you copies of. In this case, it might be letters from their lawyer, for example. But they do have to give you cost and engineering studies and things of that nature. You might have to pay some photocopy costs or something like that, but they have to turn over certain information and documents to you. And you should ask for that. That might make them squirm a little, but it certainly will shed some light on the matter and help you in challenging that. So I hope that you've gotten something out of this webinar today. In conclusion, I want to say that private well causes are often underfunded, and it's an uphill battle. It's an uphill battle to protect your right to a private water well. But be part of your state association, be involved, use your state association as that pivot point, as the hub to get you to other resources. Always stay connected at the state and local level as well as the federal level. Be ready to go when you need to go. Be ready to go at any time because you don't know when that's going to happen. So that is all that I wanted to cover today. I'll open it up for any questions if there are any. I see that we don't have any questions. So thank you very, very much for being here today. Thank you.